So today we are starting the session on last week. It could not be continued because there were some requests that we should not deal with these sessions. We should try to postpone the sessions because of the IPL and all. So we have done that. Now today we'll be continuing with where we have left on the last occasion. Just allow me to share the screen. So on the last occasion, we have covered section 5. And after section 5, we were there to cover section 5, the table 5.6, which was relevant letter, trade notice, order, removal of difficulty orders, etc. So in this, there is one order number, which is 2/2019, dated 12th March 2019. And the subject of this particular order number 2/2019 was appointment of common authority for the purpose of exercise of powers under section 73, 74, 75, and 76. These are those sections which deal with the adjudication part, wherein a show cause notice can be issued and a show cause notice has to be adjudicated. Those are the sections, section 73 and 74. And the general principles are in section 75 and 76. So therefore, this order speaks about the appointment of some common authorities. This is the order number. Just a minute. This is the order number on your screen. It says, in exercise of the powers conferred by subsection 1 of section 5 of the Central Goods and Services Tax Act, so and so, hereinafter referred to as the said act, read with notification number 2/2017 Central Tax, dated so and so, the Central Board of Indirect Taxes and Customs hereby assigns the case specified at column 2 of the table below to the Central Tax Officers specified at column 3 of the said table for the purpose specified at column 4 of the said table. So the purpose, if we read further, first, it is exercise of powers under section 73, 74, 75, and 76 of the said act in respect of the taxpayers mentioned in column 2. So these are the GST numbers. These are the taxpayers which are mentioned in the column number 2. And for these taxpayers mentioned at column number 2, the Commissioner of Central Tax, Mumbai Central, is the authority who has been given the power to be exercised under section 73 and 74 and 75 and 76. So therefore, this is one order 2/2019, which speaks about section 5 subsection 1, and therefore we have covered this in this particular section. Now let me once again go to the original just if the screen is not visible, let me know. No, this is the original screen. We are back. So 5.6 we have covered, 5.7 relevant forms. There are no relevant forms so far as section 5 is concerned. Now 5.8, which is the relevant part and an important part, which deals with the case laws. So as I've already specified on the last occasion also, and once again, I'm informing all of you that we have bifurcated the cases into, we have covered, first and foremost, we have covered only Supreme Court and High Court cases. Then we have bifurcated the cases into the cases in favor of revenue and cases in favor of assessee. So section 5 starts with cases in favor of revenue. First case, writ tax number 760 of 2021. It's in High Court of Allahabad, Geeta Traders, Ma Geeta Traders versus Commissioner Commercial Tax. It deals with section 291, that is proper officer 3, 4, and 5 of the CGST. And the issue and facts of the case were that the writ petition has been filed, wherein the validity of the jurisdiction of Deputy Commissioner of State Tax under section 74 was challenged. As we have already read, section 5 deals with assignment of powers, that a superior authority can assign his power to the subordinate authorities. And therefore, with that context, it was challenged that the Deputy Commissioner does not have the power under section 74, and therefore he cannot pass an order under section 74. And as I already requested each one of you very humbly that I intend to cover the cases, but at the same time, I'll not be able to cover in detail wherein we can cover the entire judgments, because there is a separate series that is going on. We have discontinued for the time being, but that will be continued once again. And there we'll be dealing with the case laws in detail. But the decision and principle of this particular judgment was that section 5 subsection 3 gives the commissioner a general authority to delegate all or any of his powers or functions to any other officer who may be under him. Functional and monetary jurisdiction have been delegated and assigned to various officers, including the deputy commissioner, by an office order issued by the commissioner. So therefore, it is empowered. The commissioner has the power under section 5 subsection 3 that he can delegate his powers, and therefore the challenge which is raised in the present petition fails and the writ petition is dismissed. Again, as I have specified, once again I am saying that you will get the book. Okay, there is a general query that the application for purchase of the books or the online application has been made or online payment has been done, but the books is yet to receive. Yes, it is right, because there were some last minute changes which we have done, and now the book is in print. Most probably it will hit the market in this weekend, and by the next week 110% every one of you who has applied for that book or purchased that book will be receiving that book. And as I've already specified earlier, that this link will not be there in the ebook, which will be shared by the publisher to all of you. This link will be coming out from the next edition, not from this edition. We are also working out on some online platform. Let's see whether we are able to do that or not. Moving to the another section, another case law, which is a case law of High Court of Gujarat. Nathalal Maganlal Chauhan, a very famous case this was, versus the state of Gujarat. Special Civil Application 513 of 2020. Now, in this, basically, it is section 69 which was challenged, wherein the power of arrest was challenged, but at the same time, whether this power can be delegated or not, that was the challenge. So the issue and facts of this case was that the petitioner has filed this petition before the Honorable High Court, challenging the validity of power vested under section 69 can be, whether it can be exercised by the authority upon whom the power is delegated, provided delegatee authority has reasons to believe that the petitioner has committed offense under section 132, and in such cases, the condition is precedent. Now, the decision or the principle which is laid down by this honorable court was that the same reasonable belief will be that of the authority upon whom the power is delegated. So the belief will be of the commissioner. The power under section 69 of the act can be exercised by the authority upon whom the power is delegated, provided the delegatee has reason to believe that the assessee has committed offense under section 132 of the act. Therefore, the condition precedent, reasonable belief, for the purpose of exercise of power under section 69 of the act remains the same. In short, the Honorable Gujarat High Court has said that yes, the delegation can be done. The commissioner has the power to delegate to the subordinate authorities, and the person to whom the delegation has been made can arrest the person, provided the person who is delegating the authority, that is the person who is delegating, must have the reason to believe, which is the condition precedent under section 69. तो सिंपल सा ये है कि आपको एक पावर दिया गया कमिश्नर को कि भैया आप अरेस्ट कर सकते हो, अगर आपके पास रीजन टू बिलीव है कि इसकी अरेस्ट करनी जरूरी है और सेक्शन 132 के ऑफेंसेस जो हैं वो इन्होंने किए हैं, कमिट किए हैं. सो अब एक प्रैक्टिकली अगर आप सोचें तो एक कमिश्नर अगर एक स्टेट में है तो इट इज नॉट पॉसिबल फॉर हिम टू roam around all the places and arrest the persons. So therefore, he has the power of delegation under section 5. And therefore, the Honorable Gujarat High Court has said कि अगर see reason to believe commissioner का होना चाहिए, वो important है. So if the commissioner who is delegating the powers has reason to, ये नहीं कर सकते कि आपने एक सुपरिटेंडेंट को डेलीगेट कर दिया या एक असिस्टेंट कमिश्नर को डेलीगेट कर दिया, ना कि पावर ऑफ अरेस्ट बट इवन द पावर ऑफ deciding that the arrest is important. And therefore, that cannot be assigned. You cannot delegate the authority of having reasonable belief. So reasonable belief तो आपका ही होना पड़ेगा as a commissioner. एक बार reasonable belief आपका establish हो गया that this arrest is important and necessary, उसके बाद आप उसको delegate कर सकते हो कि on the basis of these reasons to believe, I believe that this arrest is important and necessary under section 69, and I am delegating the power of arrest to my subordinate under the provisions of section 5, and therefore that is allowed. That is what the Honorable Gujarat High Court has said. देखिए क्यूआर कोड जितने भी हैं ये सारे क्यूआर कोड ओरिजिनल जजमेंट्स खोलते हैं. मैं अगर आपको दिखा देता हूँ एग्जांपल वापस के, कुछ लोगों ने शायद अभी ज्वाइन किया होगा फर्स्ट टाइम. ये सारे वीडियोस 110% ओवर द पीरियड ऑफ टाइम विल बी अपलोडिंग ऑन द यूट्यूब आल्सो फॉर द बेनिफिट ऑफ ऑल. एंड उसमें जब जब जो जो अमेंडमेंट्स आएंगे उसके हम कॉरिजेंडम्स या फिर एक एडिशनल वीडियोस हम रिलीज करेंगे जो उसके साथ हम अटैच कर देंगे. सो ये अगर आप देख रहे हैं तो एक मिनट, शायद ये स्क्रीन आपको विजिबल नहीं होगा. लेट मी जस्ट शेयर द स्क्रीन ऑफ द ऑर्डर. इफ नाउ यू कैन सी द स्क्रीन, दिस इज द ओरिजिनल ऑर्डर. तो आप कहीं पे भी देखेंगे इस पूरे बुक में you will be finding the original order. It is not an order of any other what I can say newsletter or journal. No, it is the original order of the court. Now going back to the chapters. So section 5, these are the other citations also, because क्या है, more than 4000 judgments are there. अगर हम 4000 जजमेंट को बुक में इनकॉर्पोरेट करेंगे अगर समरी और फैक्ट्स निकाल के, सो दैट बुक विल बी सो बल्कि एंड इट विल बी सो वॉल्यूमिनस कि 4-4 5-5 वॉल्यूम की बुक हो जाएगी. सो देयरफॉर जो इंपॉर्टेंट लगा दोज वी हैव डिस्कस्ड बाय फैक्ट्स एंड द डिसीजन ऑफ द कोर्ट. और जो इसके अलावा के जो जजमेंट्स हैं वी आर गिविंग द लिस्ट देयर along with the order so that you can refer. आपसे कुछ छूटेगा नहीं, you can refer those judgments and जो आपको appropriate लगे accordingly you can use those judgments. Now moving to statutory provision, section 6. Now this section as per me has its own importance. जैसे section 3 में appointment है कि डायरेक्टर जनरल होगा, फिर एडिशनल डायरेक्टर जनरल होगा, फिर ये होगा वो होगा. सो इट वाज द हायरार्की व्हिच वाज गिवन. सेक्शन 4-5 कहीं ना कहीं उन अथॉरिटीज को डेलीगेशन करना उससे रिलेटेड था जो आज मेरे को पावर दी गई, whether I will be able to delegate those powers or I am only the person who is supposed to exercise those powers. So that is answered in section 5. Now section 6, which is very, very important. It says authorization of officers of the state tax or union territory tax as proper officer in certain cases. Again, I'm repeating the heading. कई बार ऐसा होता है फ्रेंड्स कि हम बहुत एम्फेसिस देते हैं इंटरप्रिटेशंस पे और हम रेफरेंस बुक्स, कमेंट्रीज वो सब हम पढ़ लेते हैं, 1000 पेजेस पढ़ लेते हैं कि इशू पे जिस पे हम रिसर्च कर रहे हैं. लेकिन हम कई बार ऐसा देखें कि अगर हम हेडिंग करें तो भी शायद हमको इंटरप्रिटेशन मिल जाता है कि व्हाट इज द पॉइंट व्हिच इज बीइंग आइडेंटिफाइड और पॉइंटेड आउट by the heading of a section. So अगर आप देखें authorization of officers of the state tax or union territory tax as proper officer in certain circumstances, meaning thereby this is a central tax. हम जो पढ़ रहे हैं वो CGST एक्ट पढ़ रहे हैं. तो CGST एक्ट में ये सेक्शन लिखा गया है कि नाउ अंडर द एक्ट ऑफ CGST the authorization can be given to state tax or union territory tax to act as a proper officer. Otherwise तो क्या होगा सर, अगर सेंट्रल टैक्स है तो सेंट्रल टैक्स ऑफिसर हैज टू बी द proper officer. It cannot be the state tax or union territory tax if the jurisdiction of the central tax. But section 6 says that in certain special circumstances, specified circumstances in this section, even the state or the union territory officers can be or can act as an authorized officer under the provisions of CGST Act. This is what is being provided under section 6. So simple है कि authorization of officers of state tax officers और union territory tax officer के को आप proper officer assign कर सकते हो in this act. subsection 1. Without prejudice to the provisions of this Act, the officers appointed under the State Goods and Services Tax Act or Union Territory Goods and Services Tax Act are authorized to be proper officer for the purpose of this Act, subject to certain such conditions as the government shall, on the recommendation of the council by notification, specify. So therefore, it says without causing any prejudice to the provisions of this law, the officers of the state and the union territory can be authorized to be acting as a proper officer for the purpose of this Act, which is CGST Act. Obviously, there can be certain conditions which can be imposed by the government. On the recommendation, these officers will be authorized on the recommendations of the council and by way of a notification. ऐसा नहीं है कि कमिश्नर कोई ऑर्डर निकाल देगा और उससे करेगा. It has to be issued by way of a notification, and we all are aware how a notification can be issued. Subsection 2. This is the most important. और बहुत सारे judgments, बहुत सारे cases are there on this particular provision, which are either pending before the court or adjudicated by the honorable courts. But this provision is very important, so please be with me and try to understand this provision first, the provision, and then we'll go to the analysis of the case laws and all. Subject to the conditions is specified in the notification issued under subsection 1A, where any proper officer issues an order under this Act, he shall also issue an order under the State Goods and Services Tax Act or the Union Territory Goods and Services Tax Act, as authorized by the State Goods and Services Tax Act or Union Territory Goods and Services Tax Act, as the case may be, under intimation to the jurisdictional officer of state tax or union territory tax. So what does it say? It says that subject to whatever conditions are provided by way of notification, which is there in subsection 1, जिससे आप authorize कर रहे हो, जहां पे कोई भी proper officer issues an order under this Act, if any order has been issued under this Act, he shall also issue an order under the State and or Union Territory Act, as authorized by the state or union territory, as the case may be, under an intimation to the jurisdictional officer of state tax or central tax. Say for example, आज मैं central tax में कोई order pass करता हूँ under section 73 or 74. Now, the question which is very obvious will trigger to my mind कि सर, अगर मेरा central tax और state tax दोनों लगना है और इंट्रा स्टेट का ही मेरा टर्नओवर है और मेरे ऊपर लेट्स से 20 lakhs का लायबिलिटी आया, 10 lakhs इज ऑफ सेंट्रल, 10 lakhs इज ऑफ स्टेट. सो सीजीएसटी एक्ट में जो ऑफिसर्स हैं, क्या वो केवल सीजीएसटी का ऑर्डर इशू करेंगे और स्टेट गुड्स एंड सर्विसेज टैक्स का ऑर्डर कोई और इशू करेगा, स्टेट टैक्स ऑफिसर? द आंसर इज नो. इसके लिए सेक्शन 6 सबसेक्शन 2 क्लॉज ए है कि जहां पे कोई भी ऑफिसर कोई ऑर्डर इशू कर रहा है, तो he will also pass an order under the state or union territory, whichever is the applicability. वो ऑर्डर भी वो पास करेगा, but he will have to intimate to the jurisdictional officer of the state tax or union territory tax, provided the jurisdiction is of state and central. अगर jurisdiction मेरा है, then that is not required. So let us presume कि कोई सर्च का केस है जहाँ पे एडजुडिकेशन मैं कर रहा हूँ, शोकॉज मैंने दिया सेंटर का, jurisdiction स्टेट का था और मैंने शोकॉज दिया, मैं एडजुडिकेट कर रहा हूं, तो आई विल आल्सो इन्फॉर्म द स्टेट टैक्स ऑफिसर विद इन हुज जुरिस्डिक्शन दैट पर्सन और दैट मैटर इज फॉलिंग, एंड आई कैन पास एन ऑर्डर not only of the central tax which is my jurisdiction, but also of the state tax or union territory tax, as the case may be, or whatever is applicable to that particular person. अगर वो let's say सिलवास में है तो वहाँ पे UTGST निकलेगा, और अगर वो गुजरात में है तो उसमें SGST निकलेगा. Clause B, that also is very, very crucial and important. Where a proper officer under the State Goods and Services Tax Act or the Union Territory Goods and Services Tax Act has initiated any proceedings on a subject matter. This is very important line. इसलिए मैंने उसको अलग किया है. Has initiated any initiation of an action by a proper officer under the State Act or Union Territory Act on a particular subject matter no proceeding shall be initiated by the proper officer under this act on the same matter. So therefore, if any particular issue has been raised by the state or the union territory officer under their act, that is union territory or state act, then on such issue, specifically I'm saying on such issue that is on the same subject matter, a separate proceedings under CGST cannot be done. And this is vice versa. अगर स्टेट टैक्स हम पढ़ेंगे, स्टेट जीएसटी पढ़ेंगे, तो उसके केस में अगर सीजीएसटी ने कोई एक्शन ले लिया तो स्टेट वाला नहीं ले सकता. So I hope the law is very clear to all of you. I'm repeating clause B once again. बहुत लिटिगेशन है इस पे पेंडिंग और काफी एडजुडिकेशन हो चुके हैं कोर्ट में, जहां पे कोर्ट ने बहुत स्पेसिफिकली ये बोला है कि अगर एक कॉज ऑफ एक्शन है, उसी कॉज ऑफ एक्शन पे अगर एक एक्शन ऑलरेडी हो चुका है, प्रोसीडिंग ऑलरेडी हो चुकी है, भले ही स्टेट की हुई है या यूनियन टेरिटरी की हुई है और आपका जुरिस्डिक्शन सेंटर है, इट हार्डली मैटर्स. सेंट्रल वाला फिर दोबारा उसी इशू पे प्रोसीडिंग नहीं कर सकता. अगर डिफरेंट इशू है, इवन फॉर द सेम पीरियड, देन इट कैन बी डन. फॉर एग्जाम्पल, my purchases from A Limited is challenged by the state officer. My purchases from B Limited can be challenged by central tax officer. I cannot say कि already state officer ने search कर लिया या action ले लिया या proceeding कर दी है, तो now you cannot do the proceeding. The central tax officer cannot do the proceeding. That is not the case. Law says on a subject matter. So if the subject matter is same, then two simultaneous proceedings cannot be initiated. But if the subject matter is different, then two simultaneous proceeding is allowed within the law. और सर अगर मैं बैकग्राउंड बताऊं तो ये क्यों किया गया? This is the provision which gives cross empowerment under GST. This particular provision gives the cross empowerment under GST. इसके लिए एक अक्टूबर में उन्होंने एक इंस्ट्रक्शन भी निकाला था, एक लेटर था बेसिकली वो सीबीईसी का, जहां पे उन्होंने ये चीज क्लैरिफाई करी थी. और अगर आप मिनट्स ऑफ मीटिंग देखेंगे तो मिनट्स ऑफ मीटिंग में भी ये इशू रेज किया गया था कि चलिए आपने जुरिस्डिक्शन डिवाइड कर दिया सेंटर का स्टेट का, बट क्या आज अगर सेंटर का मेरा जुरिस्डिक्शन है और स्टेट को पता चलता है कि देयर इज सम लीकेज ऑफ रेवेन्यू, कैन द स्टेट ऑफिसर डू नॉट टेक एनी और इज नॉट एम्पावर्ड टू टेक एक्शन? द आंसर इज नो. उस मिनट में बोला कि अगर कोई इन्फोर्समेंट एक्शन होगा, जिसको बोला इंटेलिजेंस बेस्ड इन्फोर्समेंट एक्शन, अगर कोई इंटेलिजेंस बेस्ड इन्फोर्समेंट एक्शन हैज टू बी टेकन बाय द अथॉरिटीज, देन इट इज अलाउड. देन वहां पे क्रॉस एम्पावरमेंट है, वहां ये जुरिस्डिक्शन नहीं देखा जाएगा. एंड देयरफॉर वंस द intelligence based inquiry has been initiated or enforcement action has been initiated by one authority, let's say state tax authority, then on the same issue on which the action has been initiated, the central authorities cannot proceed. That is section 6 subsection 2 clause B. हमें ये कंफ्यूजन हो जाता है कि अगर एक बार स्टेट ने कोई एक्शन ले लिया तो सेंटर आ ही नहीं सकता. नहीं सर, सेंटर आ सकता है लेकिन उस इशू में नहीं, इसके अलावा के कोई इशू में. जैसे मैंने एग्जांपल दिया कि ए लिमिटेड की परचेज स्टेट ने टैक्स की चैलेंज की और उसके ऊपर प्रोसीडिंग की, और बी लिमिटेड के परचेजेस को सेंटर ने किया, तो बोथ द साइमल्टेनियस प्रोसीडिंग्स फॉर द सेम पर्टिकुलर ईयर इज वैलिड within the four corners of section 6 subsection 2 clause B. Moving to subsection 3, any proceedings for rectification, appeal and revision wherever applicable, any proceeding for rectification, appeal and revision wherever applicable of any order passed by an officer appointed under this act, who is appointed under section 3, shall not lie before an officer appointed under the State Goods and Services Tax Act or Union Territory Goods and Services Tax Act. So this simple says कोई भी rectification, appeal या revision जो भी applicable है of any order which is passed under this particular act, which is CGST. So this rectification or appeal or revision will not lie before the state tax or the union territory. Meaning thereby, if an order, if a show cause notice has been issued by CGST, the order also has been passed by the CGST, you cannot go and file the appeal before the SGST saying that mera the jurisdiction is SGST. No. Even if your jurisdiction is SGST, your appeal has to be filed against the order of the CGST before the CGST appellate authority, and it will be decided also finally by the CGST authorities. वो आप यहाँ पे ये प्ली नहीं रख सकते कि सर मेरा jurisdiction स्टेट है तो मैं अपील तो स्टेट में फाइल करूंगा. नो, Since the order has been passed by the CGST, the appeal or revision or rectification will also be decided by the CGST and not by the state officer. This is what is provided in section 6, subsection 3. Now, this is the law. Relevant amendment, there is no amendment in this particular provision. Relevant notification 9/2017, this we have already done. काफी बार हमने देख लिया है जहाँ पे ये सेक्शंस को उन्होंने इम्प्लीमेंट किया. तो सेंट्रल गवर्नमेंट ने 1 जुलाई से ये इम्प्लीमेंट किया है सेक्शन 6 को. It is not from 22nd of June. Then 39/2017, this also we have seen cross empowerment of the state GST officers for sanctioning of refund. इसमें क्या था सर, मैं अगर मेरा रिफंड भी होगा तो रिफंड भी 1 करोड़ रुपए का रिफंड लेना होगा तो 50 लाख CGST का कंपोनेंट होगा, 50 लाख SGST का कंपोनेंट होगा. तो क्या मेरे को 2 ऑर्डर पास करने होंगे, CGST में अलग और SGST में अलग? नो, दैट इज नॉट द केस. सो ये इन्होंने क्लैरिफाई किया था कि अगर CGST वाला ऑफिसर ऑर्डर पास कर रहा है रिफंड का, तो वो स्टेट के पोर्शन का भी he will be acting as an officer for the state also, so far as the purpose of sanctioning of refund of that particular case is concerned. So therefore, CGST officer can certainly pass or sanction a refund qua the SGST amount, and the vice versa is also true. So this is 39/2017. Then comes 10/2018. 23rd January 2018. This is cross empowerment of state tax officers for processing and granting of refund, and the amendment has been made in notification number 39/2017. So this we have already discussed, so I'll not be dealing into that. मेरा रिक्वेस्ट ये है कि आप ये बुक आ जाता है या मटेरियल आ जाता है, दैट्स ओके, बट अदरवाइज भी स्क्रीन पे आपके सामने है, आप QR कोड यहाँ से भी स्कैन कर सकते हैं, अदरवाइज ये नंबर्स आप नोट कर सकते हैं, एंड देन यू कैन रेफर दोस these things. And if any query is there, I have already stated that you can either contact me, you can mail me, or you can contact my team for the queries, and I'll be more than happy to reply your queries. Then is relevant rules. There are no relevant rules so far as section 6 is concerned. Then relevant notification. This we have already discussed, 39/2017. Then comes relevant circular. There is no circular which is relevant here. Now come relevant letter. Now this is the letter which I was referring, October 2018. This is a letter which clarifies the ambiguity. So let us first read the subject description. It says clarifications on ambiguity regarding initiation of enforcement action by central tax officers in case taxpayers assigned to state tax authority and vice versa. So there is no restriction whatsoever, absolutely no restriction. In case of any enforcement action, there is 100% cross empowerment allowed. And then it further says section 2B will be taken into cognizance, and once an action has been initiated by one authority on a particular subject matter, the other authority cannot proceed further on the same subject matter. So let us now see this letter, and this letter will clarify most of the things. And this is an important matter. There are a couple of judgments also of the Gujarat High Court which have been argued by me, like Ambika Krishan and all, जहाँ पे इस लेटर का cognizance लिया था, हमने challenge किया था, and accordingly the court has given in our favor that once an authority initiates, और बाकी कोई authorities अगर action लेती भी हैं, ऐसा नहीं बोल सकते कि वो action नहीं ले सकती, लेकिन वो proceedings नहीं कर सकती. तो action लेती भी है या कोई information उनके पास आती है, कोई intelligence आती है, then intelligence has to be transferred to the authority who has initiated the action first. That is what this letter says. Let me read for the benefit of all of you. And this is the intention of this particular series. हमें कोई जल्दी नहीं है. Today only section 6 I will be covering. We will read one section each day. तो भी sufficient है. भले ही 200 दिन लगेंगे, 400 दिन लगेंगे, it doesn't matter. The purpose is that we need to read threadbare. हम जो भी important circulars है, notifications है, we'll try to cover everything. So this letter of 5th October 2018, what does it say? It says it has been brought to the notice of the board that there is ambiguity regarding initiation of enforcement action by central tax officers in case of taxpayer assigned to the state tax authority and vice versa. So GST minute में अगर आप देखेंगे 9th GST काउंसिल का मिनट जो नेक्स्ट पैराग्राफ में आ रहा है, वहां पे क्या हुआ था, ये चीज डिस्कस हुई थी कि हाउ द असाइनमेंट ऑफ द केसेस हैज टू बी डन. सो उन्होंने बोला कि अगर वो लो है, उनकी टैक्सेबल अमाउंट कम है या स्मॉल टैक्स पेयर्स हैं, तो इट विल बी असाइन 90% टू द स्टेट, 10% टू द सेंटर. अगर बड़े हैं So 50-50% center and state. So now once let's see I am assigned to the state. Ambiguity ये था कि क्या सेंट्रल टैक्स ऑफिसर मेरे अगेंस्ट में एक्शन ले सकता है? द आंसर इज यस, बिकॉज इन्फोर्समेंट एक्शन में या इंटेलिजेंस बेस्ड एक्शन में कोई रिस्ट्रिक्शन नहीं है, वहां आपका jurisdiction will not come into play, and therefore I am stating again that this is giving cross empowerment. Even if the jurisdiction is of state or the jurisdiction of center, the other authority, in case of state the center, in case of center the state, have the power to initiate an action which is enforcement action, which is intelligence based enforcement action, that can be done. Further, it says in this regard, GST Council in its 9th meeting held on 6th January 2017 had discussed and made recommendation regarding administrative division of taxpayers and concomitant issues. The recommendation in relation to cross-empowerment of both tax authorities for enforcement of intelligence-based action is recorded in para 22 of the agenda note number 3 in the minutes of the meeting, which reads as follows. Both the central and state tax administrations shall have the power to take intelligence-based enforcement action in respect of the entire value chain. When it says entire value chain, इसका मतलब है A से B को जा रहा है, B से C को जा रहा है, C से D को जा रहा है. A का jurisdiction center है, B का state, C का state, D का center. तो ऐसा नहीं है कि सेंटर वाला केवल A और D के अगेंस्ट में एक्शन ले सकता है. He can also take action against the B and C. Therefore, the entire action or the action can be taken in the entire value chain. So A, B, C, D चारों के action भले उसका jurisdiction state है, can be taken by center, which is decided by the GST Council. It is accordingly clarified that the officers of both central tax and state tax are authorized to initiate intelligence-based enforcement action on the entire taxpayer's base, irrespective of the administrative assignment of the taxpayer to any authority. The authority which initiates such action is empowered to complete the entire process of investigation, issuance of SCN, adjudication, recovery, filing of appeal, etc., arising out of such situation. So therefore, it is now very clear, if as a center, I take an action against the person who is otherwise having the jurisdiction of the state, I have to initiate. If I have initiated, I'll have to conclude also. So therefore, I'll be eligible for issuance of the show cause notice, adjudication thereof, if any appeal is filed, then deciding their appeals. So this can be taken cognizance of section 6.2 जो हमने पढ़ा clause B and section 6.3. 4. In other words, if an officer of the Central Tax Authority initiates intelligence-based enforcement action against a taxpayer administratively assigned to the State Tax Authority, the officers of the Central Tax Authority would not transfer the said case to the state tax counterpart and would themselves take the case to its logical conclusion. So therefore, CGST will finally conclude on this, even if the jurisdiction is of state. Similar position would remain in case of intelligence-based enforcement action initiated by the officers of state tax authorities against a taxpayer administratively assigned to the Central Tax Authority. It is also informed that GST is already making changes in the IT system in this regard. So therefore, this was an important letter, I would say. Now let us go back to the chapter. So therefore, we have covered this letter, relevant forms. There are no relevant forms. Now comes the relevant judgments. First block, cases in favor of assessee. There is no Supreme Court, so therefore Supreme Court is not listed. Otherwise, we have the order. First, we will be discussing Supreme Court, then High Court. This is a judgment of writ petition number 1629 of 2021, decided by the Honorable High Court of Calcutta, Raj Metal Industries and others versus Union of India, a famous order of 24th March 2021, Calcutta High Court. The facts were, petitioner have filed a writ petition contending that the proceedings were pending under the CGST and thereafter a summon dated so and so has been issued by the state GST. Petitioner has also challenged the blocking of credit ledger. So blocking of credit ledger will not be covering. So यहाँ पे CGST में already action हो चुका था. State का भी letter आया, summon आया. So now they have moved to the court saying that already CGST was continuing the proceedings. The where do from the state officers are coming. They have no jurisdiction. The Honorable Court in this particular case has said that the summons issued on so and so date by the state GST is prima facie in violation of Section 62B of the WGST Act, WBGST Act, West Bengal GST Act. Accordingly, directed to stay of the above summons and any proceedings there under. With regard to blocking of the electronics, so therefore it is not required to be touched upon. I'll not be dealing with that. So it is important कि 62B का violative माना and the court has stayed that particular summon. This matter is yet to be adjudicated finally, but whatever was the interim relief given, we have tried to incorporate that. Then comes a special civil application 23279 of 2019, Suresh Gadeja versus State of Gujarat, Anmol Traders. So therefore, this is a case where again an interim is there. A summon was challenged. The issue and facts is the competent authority under CGST as well as the competent authority under Gujarat GGST separately commenced investigation against the assessee on the same subject matter. So this is important because we have already discussed that if the subject matter is same, two authorities cannot come. If the subject matter is different, then two authorities can come. So therefore, assessee filed a writ petition contending that the authorities under SGST were well aware that the authorities under CGST are already investigating the matter, and therefore there cannot be two parallel proceedings for the same cause. And the judgment of the interim which has been given by the court was that by way of ad interim relief, the respondents were restrained from taking any coercive action against the assessee pursuant to the impugned inquiry proceedings. Next is, it's an important judgment again, Godrej and Boyce Manufacturing Company Limited, High Court of Allahabad, 587 of 2018. This was again in favor of the assessee. Now here the sections which were relevant was 129, Section 4, Section 20 of the IGST, and Section 6 and 8 of the CGST, and Rule 138. So it deals with the electronic of e-way bill. The goods and conveyance were detained by the state authority on the ground that e-way bill in form so and so was not carried along with the conveyance. Although in few e-way bill in form so and so was carried, validity of the same was expired as per the Commissioner's circular dated so and so, and so and so, wherein the time limit for e-way bill is prescribed as 10 days for e-way bill, 2 time limit for is 48 hours is prescribed. So therefore, there are 2 e-way bills, one 10 hours and 2 48 hours is prescribed, 10 days and 48 hours. However, Rule 138 was made effective on 1st February 2018, wherein different time limit was prescribed. Because वहां पे तो उनका टाइम हो गया था कि 100 किलोमीटर का इतना आवर्स रहेगा, उस तरीके से दे हैव डिवाइडेड इन रूल 138. Decision or principle. So in this, the Honorable Court has said let me read for. The court observed that legislative changes were made in such a quick succession that field authorities could not track themselves with such changes and hence adhered to compliance of provisions which stood already substituted by new provisions and earlier ones have become otious. Notification number so and so, whereby Rule 138 was completely changed by substitution and made effective from so and so date. It appears escaped attention of the authorities concerned, though it is this provision which has to be complied by the petitioners. It appears that for the field authorities, there was a gross chaos on account of quick changes in the relevant provisions. Hence, authorities concerned could not appreciate what provision is supposed to be followed by concerned person and what is actual default, if any, which has been committed by such person. The pace of change derailed respondent authorities also in their understanding as to which provision has to be followed and implemented, and what has to be observed, applied, obeyed by the petitioners and their transporters. This is how impugned orders have been passed under a clear misconception of not downloading the e-way bill 01 or 02 as the case may be. The Rule 138, which has come into force from 1st February 2018, the forms required to be downloaded by dealers or transporters are different. So neither it can be said that the petitioners have deliberately committed any fault or disobeyed law intentionally or fraudulently, particularly when respondent authorities themselves were not clear. It also cannot be said that there is any intention of evasion of tax on the part of these petitioners. The seizure orders, show cause notices issued under section 129(3) and final orders, if any, are not sustainable in law. The writ petition is allowed to the extent that seizure orders, show cause notices, and final orders impugned in these writ petitions are hereby set aside. So therefore, the important part is the court has appreciated that there are so many changes which are taking at so much of the pace that even the departmental authorities, the respondent authorities are not in a position to cope up with that. And therefore, even they are not aware. Although it is the duty and responsibility of the petitioner to comply with the law, to comply with whatever new instructions have came. But since it was not in the position of, or even the respondent authorities were not aware, so the Honorable Court has deemed it fit that since there was no intention of evasion of tax, to quash the orders, the show cause notices, and the seizure orders pertaining to or impugned in this particular writ petition. Moving further, Going Solution Private Limited versus Union of India, 5040 of 2021, the Honorable High Court of Delhi. In this, what has happened, petitioner has filed writ petition contending that the proceedings already completed by the state tax officers, and after considering his reply, same was closed. Thereafter, the central tax officer has initiated the proceeding on the same subject matter. Here, the Honorable Court was pleased to grant ad interim relief by way of staying on the proceedings initiated by the central tax officers and was pleased to issue notice. Next is High Court of Madhya Pradesh, 1414 of 2021, dated 29th January 2021, Jayaprakash Associates Limited versus Union of India. In this, the assessee has averred that while it was already filed appeals, it has already filed appeals against the main assessment orders issued by the state tax officer SGST Riva, which was pending. Joint Director General of GST Intelligence Bhopal could have issued the impugned show cause notice covering the same period for the same amount of interest on the delayed payment, and that despite filing reply, no decision has been taken on the reply. The court has said that assessee has submitted that according to section 6(2)(b), where one proper officer either under SGST or under UTGST has initiated any proceedings on a subject matter, no proceeding shall be initiated by another proper officer under this act on the same subject matter. The court directed the Joint Director General of GST Intelligence, Bhopal, to first deal with and decide on the petitioner's objection in accordance with law before proceeding further. So this was Madhya Pradesh High Court. Then comes Essex Trading Limited versus Assistant State Tax Officer, again 420, 129, 138 rule. So similar case we have already covered, so I'll not be dealing with this once again. Now, next is Honorable High Court of Madras. Writ petition number is 2391 of 2023, 2481 of 2023, 30th January 2023, the latest recent judgment favor of assessing. Now the facts are, a show cause notice was issued by the central authority on 29th July 2022 against the petitioner under CGST Act. Another impugned show cause notice in DRC 01 dated 21st October 2022 was issued by Tamil Nadu GST Act. When the proper officer under the CGST has already initiated proceedings against the petitioner on the same subject matter, no proceeding shall be initiated by the proper officer under the TNGST Act. The petitioner has challenged the impugned show cause notice dated so and so on the ground that same has been issued in violation of Section 62B of the TN-GST Act. Now, what does the court say? The writ petition is disposed of by directing the petitioner to submit a reply to the impugned show cause notice within a period of 3 weeks from the date of receipt of a copy of this order. And on receipt of the said reply, the first respondent shall pass final orders on merits and in accordance with law, after giving due consideration to the objections raised by the petitioner in the reply within a period of 4 weeks thereafter. So this is how the court has decided that they have already directed the authorities, directed the petitioner to file the reply to the show cause notice, and direction to the authorities to decide those show cause notice within a time-bound manner within a period of 4 weeks. Next, again, High Court of Madras 3033 of 2023, 3125 of 2023, 6th February 2023. TVL Metal Trade Incorporation versus Special Secretary 62B of the CGST Act. The petitioner has received a summon dated 18th October 2022 under Section 70, subsection 1 of the CGST Act. The petitioner has submitted a reply to the impugned summon on 27th October 2022. Admittedly, no final decision has been taken by the fifth respondent to initiate action against the petitioner under the TN-GST Act. The petitioner has only been called for upon to produce documents under the impugned summons dated 18th October 2022, and he has also been called to come for personal hearing. Admittedly, the petitioner has not participated in the personal hearing, and instead he has chosen to file this writ petition challenging the impugned summons. The petitioner has challenged the impugned summons dated so and so of the TN-GST Act. Now, what does the court says? The Honorable Madras High Court says that since the petitioner did not participate in the personal hearing afforded to him as per the summons, this court deems it fit to grant one more opportunity to the petitioner to participate in the personal hearing. The personal hearing is fixed by this Honorable Court on 16th February 2023, and on that date, he has to appear before the fifth respondent and state all his objections with regard to the impugned summons. For the foregoing reasons, this writ petition is disposed of by directing the petitioner to appear before the fifth respondent on 16th February 2023 at 10:30 a.m. without fail and state all his objections in line with his reply dated 27th October 2022 sent to the impugned summons. And the fifth respondent shall consider the petitioner's objections on merits and in accordance with law, and thereafter decide as to whether the petitioner can be prosecuted once again under the TN-GST Act when the central authority has already prosecuted him under the CGST Act. So again, two simultaneous proceedings cannot continue. That is what is being decided in this. Next, again, it's a similar judgment. Again, Madras High Court. So I'm skipping that, moving to next table, which is in favor of the revenue. And when I say in favor of the revenue, the only thing is if the subject matter is different, two simultaneous proceedings can be there. That is what is making it in favor of the revenue. Otherwise, it is very clear, the law is very clear that two simultaneous proceedings on the same subject matter cannot be continued. Honorable High Court of Allahabad, 1169 of 2021, Ajay Verma versus Union of India, Section 73 of the CGST Act. Now, the administrative jurisdiction was over the assessee is with the CGST officer. However, the learned SGST officer has initiated the proceedings under Section 73 of the CGST and issued the impugned order under Section 73. Agreed by the same, the petitioner has approached this present High Court. Honorable High Court has held that the petitioner has submitted itself to the jurisdiction of SGST officer and participated in the assessment proceedings without raising any objection as to jurisdiction. Impugned show cause notice and assessment order did not suffer from any inherent lack of jurisdiction, and instead it was a result of the contributory error of jurisdiction by the state officer. The situation may have been corrected by the state officer by alerting the central officer to finish the assessment process if the petitioner complained at the beginning or during the assessment proceedings. So therefore, since there was no complaint and even rather the participation was there, the petitioner has participated in the proceedings initiated by the state officer. The Honorable High Court has said then nothing wrong in that. It is deemed to be a valid proceeding. Next is Honorable High Court of Delhi 12202 and 35806 of 2021. Indo International Tobacco Limited versus Vivek Prasad, Additional Director General, DGGI. The facts are investigation against the various assesses have been initiated by the various authorities. Multiple summons from multiple authorities have been issued to the petitioner. Ultimately, common link involving the petitioner was found, and therefore, the entire case investigation was transferred to the Ahmedabad zone. Honorable High Court held that Section 62B and Circular dated 5th October 2018 that we have referred just now were not applicable to the present case, since multiple investigations and proceedings may lead to contradictory conclusions by jurisdictional authorities, and transfer of investigation by proper officer having limited territorial jurisdiction to proper officer having pan-India jurisdiction depends on facts of each case. So this is what the court has said कि DJJ has the pan-India jurisdiction. So therefore, जितने भी दूसरे jurisdictions थे वहां से वो transfer उन्होंने कर दिया, and this transfer was valid because multiple authorities अगर उसको adjudicate करेंगी, भले different issues हैं, तो there are reasons कि contradictory views आएंगे. So therefore, the entire matter was transferred to DJJ Ahmedabad, who is having the pan-India power, and accordingly they will adjudicate the issue or investigate the issue rather. Next is 666 of 2022, Honorable High Court of Allahabad, GK Trading Company versus Union of India. Again, a very important judgment, a good one. A survey was conducted at petitioner's premises on 30th May 2018, in which no business activity was found, and thereafter, petitioner was summoned by Deputy Commissioner on so-and-so date under Section 70 of the UP GST Act, requiring him to submit details of purchase, sale, and other documents. Again, summon was issued on 14 September 2020 by Assistant Commissioner to submit further explanation with respect to certain ITC. Further, some inquiry was being conducted by the DGGST, Meerut Zonal Unit, Meerut, and issued 2 summons requiring the petitioner to appear in person, to tender a statement in person, and submit certain documents, but the petitioner has not responded to the summons. Petitioner neither appeared before the authority, that is DGGST Meerut Zone, nor submitted any detail, and instead merely wrote a letter that detailed inquiry is being conducted by UPGST. So again, there is a question कि भाई GST अगर आ गया, UPGST has already issued a summon. So इन्होंने कहा कि नहीं अभी already UPGST has initiated the action, so therefore we will not cooperate with you. Now this is a very good judgment. Please try to be with me and try to understand the law which is laid down by this Honorable Court, High Court of Allahabad, in this particular judgment. The word inquiry in Section 70 has a special connotation and a specific purpose to summon any person whose attendance may be considered necessary by the proper officer, either to give evidence or to produce a document or any other thing. The process of inquiry under Section 70 is specific and unified by the very purpose for which provisions of Section 14 of the Act confers powers upon the proper officer to hold inquiry. The word inquiry in Section 70 is not synonymous with the word proceedings in Section 62B of the UPGST or CGST Act. The word any proceeding on the same subject matter used in 62B, which is subject to conditions specified in the notification issued under subsection 1, means any proceeding on the same cause of action and for the same dispute involving some adjudication proceedings, which may include assessment proceedings, proceedings for penalties, etc., proceedings for demand and recovery under Section 73 and 74, etc. Section 62B of the CGST prohibits a proper officer under the Act to initiate any proceedings on a subject matter where on the same subject matter proceeding by a proper officer under the UPGST Act has been initiated. In this case, there is no proceeding by a proper officer against the petitioner on the same subject matter related to 62B of the UPGST Act. It is merely an inquiry by the proper officer under Section 70. The writ petition fails and is dismissed. So therefore, the important aspect is only issuance of summon does not create any weightage so far as 62B is concerned. There has to be a proceeding which has to be initiated, and that has to be an intelligence-based enforcement action, not only a summon. Moving further, High Court of Chhattisgarh Daiichi Iron and Steel Private Limited versus Chhattisgarh GST 42 of 2022. This is again in favor of revenue. Authorities issued show cause notice for tax demand, allegedly dealing with fake dealers and fake invoices subsequently. Thereafter, DGGST have searched the premises of the taxpayer and have arrested one of the directors of the company, as the company has availed bogus ineligible ITC worth 60 crores. Company has filed the writ petition containing the proceedings of arrest is beyond jurisdiction. Again, their intention is that already action has been taken. Show cause notice has already been issued. So how DGGST can arrest? This court does not find any substance in the arguments of the petitioner. When they say that the investigation and proceedings now initiated is one, which is hit by 62B of the CGST Act of 2017, what has all to be appreciated is the fact that there is a clear distinction between proceeding drawn for the demand of tax evaded by the petitioner establishment and the investigation be conducted by the Department of DGGST Intelligence. In respect of an offense committed by an establishment by way of using bogus and fake invoices and illegally availing ITC, which the petitioner establishment otherwise was ineligible. So far as the judgments referred to in by the petitioner is in support of his contention, what cannot be lost sight of is the fact that those judgments were rendered under entirely different contextual background as compared to the factual metrics in the present case. And the ratio laid down in those judgments are also not what could be applied at this juncture. Even the judgments of the division bench of this honorable court referred to by the petitioner establishment again is one which has been decided in an entirely different contextual background as compared to the facts of the present case. And those judgments are distinguishable on the facts itself. Therefore, the petition is dismissed. So, simple सा है, आज एक एक्शन आपके अगेंस्ट में हुआ या शो कॉज नोटिस इशू हो गया, दैट इज अ पार्ट ऑफ प्रोसीडिंग विच इज एन असेसमेंट प्रोसीडिंग. बट अगर एक इन्वेस्टिगेशन होता है विच इज इंटेलिजेंस बेस्ड इन्फोर्समेंट, then thereafter the initiation and 62B gets hit. So let us presume DGGST has already started the investigation, then state comes, so that is invalid and it will be hit by 62B, otherwise it is not going to be hit. Next is Honorable High Court of Madras, Coupon Gounder PG Natarajan versus DGGI 15708 of 2021. Again, notice for discrepancy in return has been issued by the state tax authority, which is pending against them. In the meantime, DGGI issued summons, wherein respondent is making an inquiry in connection with the petitioner's company, and the petitioner was directed to give evidence or produce document. The petitioner considers such summon issued by DGGI as out of jurisdiction by virtue of section 62B. So again, the question is already there was a notice for discrepancies in the return, and then DGGI has issued a summon for certain evidences to be given or the documents to be produced. This cannot be hit by 62B. So the Honorable Court has similarly adjudicated that this cannot be hit by 62B. Next is High Court of Punjab and Haryana, Kaushal Kumar Mishra versus the Additional Director General. This again is an important judgment, a good one, 21387 of 2022. See the facts. Investigation against the petitioner has been initiated by DGGI Ludhiana. Subsequent to the investigation already undertaken by the Commissioner CGST Department on the ground that the assessee has availed fake input tax credit. Now, assessee filed instant appeal contending that Commissioner CGST has already initiated action against the assessee and other authorities should not interfere with such proceedings already initiated. Now, what was the decision of the court? Court has observed that where different officers appointed under section 6 and 3 and 6 of the CGST are independently investigating altogether different matters. So again, the question is of same cause of action. So when they are investigating independently different matters involving contraventions of prima facie cognizable and punitive offenses in CGST, without any overlapping, such investigation is not barred by 62B. It should be noted that information received by a department that assessee had passed on fraudulent ITC to its sister concern, ESA Rolling Mills, which is owned by his wife, is being investigated by DGGI Ludhiana, while the investigation conducted by Commissioner CGST is limited to information provided by DGGI Lucknow CGST Agra and DGGI Ghaziabad about the fake availment of ITC by SSC proprietorship from certain bogus firms. Hence, it was held that different officers are independently investigating altogether different matters without overlapping, and hence there is no reason to interfere with the aforesaid investigation. Again, the basic law which is laid down by this Honorable Punjab and Haryana High Court is again the same, that if independent investigations are being done, if independent inquiries are being done, and there is no overlapping, then in that case, Section 6(2)(b) is not going to be hit. Next is Honorable High Court of Rajasthan, Sangan Area Spinning Mills Limited versus Union of India. Again, the petition has been challenging the validity of 6(1) of the CGST and prayed to set aside the show cause notice which was issued to them. Again, that was not accepted. So the court is of the opinion that the challenge to the provisions of 6(1) has not been made at all. The constitutional authority, such as GST Council, was created to lay down the policy which are binding on the state and union, which are authorized to collect the levies under the GST. The Act also unifies levies such as central excise, service tax, and state VAT enactment under one regime. Naturally, to cater to such a complex structure, common principles in the form of mechanism and authorities were devised. It was in these circumstances Section 6 was enacted, which enables the officers appointed under the state tax and union territory and also authorized the proper officer for the purpose, subject to certain conditions prescribed by the central government. So far as the challenge to the circular and the show cause notice is concerned, the court is of the opinion that the current circular merely works out the authorization under Section 6(1). It is also a matter of policy. Furthermore, the court was informed that the assessment has been completed pursuant to the show cause notice dated so and so. In these circumstances, it is not appropriate for the court to consider the validity or otherwise of the show cause notice, having regard to the fact that an alternative remedy by way of an appeal exists in favor of the petitioner. The court has directed that, if required, the petitioner shall avail a remedy of the appeal, which shall be decided on merits. So therefore, this case, since it was adjudicated, the court has not entertained and they have remanded or relegated back to the appellate authority. Again, High Court of Rajasthan, AMP Motors Private Limited, Central Board of Indirect Taxes and Customs, Section 673/71. The petitioner challenges the show cause notice issued by the state authority under Section 73 of the Act on the ground of lack of jurisdiction. The petitioner argued that once the assessment matter was assigned to the Central Taxation Authority, the state authority did not have any jurisdiction to initiate proceeding under 73. The petitioner alleged that the certain statutory provisions were violated by the state authority. Simple है कि अगर आपका central का jurisdiction है, state cannot come forward. Again, the court was not convinced. The court observed that the revenue opposed this argument, stating that the petitioner relied on unamended provisions. The petitioner was aggrieved by the imposition of tax based on discrepancy of input tax credit details in GSTR 2 capital A and GSTR 3B. The High Court dismissed the writ petition and held that the petitioner may raise various grounds except the issue of jurisdiction, which has been raised in the petitioner. The authority is required to consider these grounds. If the petitioner suffers any orders prejudicial to its interest, it is open for the petitioner to take such remedy as may be available to it under the law. The court was not convinced and they have dismissed the petition. Next is High Court of Madras. Coupon counter PG Natarajan. This we have already covered. This is, I think, it is repeated. This was the first one that we have covered. Just look at this. Just 1 minute. Anyway, this as per me has already been covered. It is double. So again, High Court of Madras, the same ratio has been held. I'll read the last paragraph. The court held that the issuance of summons for conducting an inquiry and to obtain a statement from the petitioner could not be construed as a bar under Section 62(b) of the Act. The court also observed that the keywords occurring in both provisions in any inquiry and proceedings on the same subject matter indicate a crucial difference between the two provisions Therefore, the court held that no grounds were made out for quashing the summons issued under Section 70 of the Act. The writ was dismissed in favor of the revenue. So, friends, this was Section 6 we have concluded, and most of the cases I've tried to incorporate and the facts and the issues we have discussed, and then the list is there. Only one case is remaining, and there are two judgments which are not incorporated, as I have stated. Ambika creation is one of those, in which the Honorable Gujarat High Court has taken the cognizance of that letter, 5th October 2018, and have said that the authority who has initiated the action must conclude the proceedings. So I think we should stop here because Section 6 we have covered. Tomorrow we'll be dealing with Section 7, which is one of the most important sections, which deals with the taxable event under GST, which is supply. So till tomorrow, I'm once again thankful to each one of you, but let me once again point out, kindly sit with the books, with the act rules, and also the piece of paper and a pen, so that if anything important you come across, you can note it down and then you can refer it as per your convenience. With this, I'm thankful to each one of you. We'll meet tomorrow again. Thank you. Thank you so much.